Hello and welcome again to Jaded Law Channel. As always, it is that law-based channel where your legal needs are met, where your questions are answered, and of course your issues are adequately resolved. I remain your host, Mrs. Omongo Ogbe. I want to thank you for the comments. Someone asked a question which I want to address today. The question was to the effect as to who carries out the wishes of the testator. So in answering this question, I would want to look at some important terms in a will. Okay, the first one is a testator. I've explained that the testator is the person who wishes to dispose of his assets. Okay, the person who, upon his death, wishes that his assets be distributed, managed, run in the particular way. So that's the testator. The other term is a beneficiary. The beneficiary of a will is a person who benefits from the will, as the name implies. Then the third important term that I need to explain is an executor. An executor of a will is the person appointed by the testator to carry out his wishes. And usually these are people of integrity, people who would not compromise their positions. They usually are not beneficiaries of the estate, because if they are made beneficiaries of the estate, there would be conflict of interest. So these executors, and a number of times we have people who are professional executors. Sometimes you have lawyers, okay, who are appointed to be executors of the estate of a deceased person. Someone who is a neutral party, who is firm, who would not compromise his stance towards ensuring that the deceased person has his wishes adequately, sufficiently carried out. So that is actually the way by which a deceased person has puts in place the structures on how his estate should be managed. And in the will, the executors are named. They are also informed. A number of times, some of them even have copies of the will. Now, when a will has been prepared, what we do is that we have them lodged. A will can be lodged at the probate registry of the High Court of every state. Of course, every High Court has a probate registry. You make a particular payment and then the will is lodged there. A copy usually left with a lawyer who prepares the will, who may also be an executor of the will if the testator so requests, or it could be neutral parties. And then a will can also be lodged in the bank. Okay, so upon payment of a particular amount, if you bank with that particular bank, or even if you don't and the bank carries out those kind of services, you can also lodge your will there for safekeeping. And when the person dies, what happens is usually the lawyer contacts the beneficiaries, gets also to the probate registry to make that information known, and then a date is fixed for the reading of the will. Every person who is connected with the deceased, of course, that should be there at the time of the reading of the will is present, and then the will is read. Okay, so that's basically what an executor of your will does, and it's such a seamless, stress-free process compared to the processing of letters of administration where a person dies intestate. Okay, I hope I've been able to answer that question for you, and should you have any other question, please do not hesitate to ask. Okay, I'm sure you've learned something today. Again, ignorance of the law is no excuse. I would urge you, plead with you, to subscribe to this channel, get other people to do the same thing. We have tons and tons and tons of good content for you, and we look forward to seeing you again next week. Please remain safe, be good, and God bless you.